So another federal court ruled that the federal laws restricting machine gun possession are in fact a violation of the Second Amendment. But AG Bondi and the Trump administration are still appealing that decision and will likely continue to argue that those types of firearms are not protected arms under the Second Amendment. So let's break down what is happening in this critical case. Now, before we jump into this video, I want to just mention that if you guys want to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. You know, YouTube loves to unsubscribe people, so check that. Make sure YouTube has not unsubscribed you. And then also you can check out the free legal guide that we have available for you guys. I will link that down below in the detail section in the pinned comment. All you have to do is put in your email and we send you over that free PDF. And then we also do some follow-up additional educational emails. And you can check out my website, armscholar.com, where we have that legal guide and a lot of other things that you can check out as well. Now, as I mentioned in the intro, in this video, we're going to be talking about a critical Second Amendment machine gun challenge that's currently in front of the Fifth Circuit Court of Appeals. Recently, another federal court dismissed a machine gun possession charge using the Second Amendment and also the recent Bruen decision by the Supreme Court. This was a huge win, striking down machine gun restrictions as a violation of the Second Amendment. This decision came out of a Mississippi District Court issued by Judge Carlton Reeves in a case called U.S. versus Brown. So U.S. versus Brown is the case we're talking about here that is in the Fifth Circuit. However, this decision was citing heavily to a prior case, a different case called U.S. versus Morgan. In that prior case, a federal judge in Kansas also found that a machine gun possession charge was unconstitutional and violated the Second Amendment. However, in both of these cases, we have now seen that the Trump DOJ and Pam Bondi's office continue to argue that these types of items are not protected arms and that they can restrict the possession of these items under the GCA. Recently, the Morgan case went in front of the 10th Circuit Court of Appeals, and the Trump DOJ continued to argue against the Second Amendment and argue against machine gun possession. That is likely also going to trickle into this Brown case in the Fifth Circuit because this case is moving along and is likely heading to Fifth Circuit oral arguments. Now, in this Brown case, the lower court judge stated that, as Judge Brooms explained in the United States versus Morgan case, this statute criminalizes the mere possession of such weapons without regard to how the possessor uses them. If an individual purchases such a weapon and locks it away in a gun safe in his basement for 20 years without ever touching it, he is as guilty as the violation of the GCA as someone who takes that same weapon out into public streets and displays it in an aggressive manner. So there he's showing that the law and how it blanketly bans the gun possession of these types of items is unequal. It treats you the same way whether or not you have the gun and just simply keep it in your home versus someone who goes out and uses it maybe in a criminal manner. He went on to state that every appellate court's prior precedent was rendered obsolete. Under the new standard by the Supreme Court, the government must prove that its desired firearms restrictions, which here means the statute criminalizing simple machine gun possession, is consistent with the nation's historical tradition of firearms regulation. So there he's saying all the prior precedent relating to the Second Amendment is essentially void now because of Bruen. Here, the historical justifications that the government presented for the machine gun prosecution of Mr. Brown included things like the Statute of Northampton relating to the riding and going armed offensively to the fear and terror of good citizens. But the judge here in the Brown case rejected that as not valid historical support. The judge pointed out that the record shows there are at least 740,000 machine guns lawfully possessed within the United States, and that was as of 2021, probably way more now. And he states that that's not a small number of machine guns of these types of items, and the federal government failed to explain how that high number of possession does not actually meet the common use standard. Now, to contest that number of machine guns in common use, the federal government relied on a prior Fifth Circuit case called Hollis. However, that case, like the judge here explained, is now invalid under Bruen. And also in the Hollis case, that prior case in the Fifth Circuit, the accounting of these machine guns was only about 175,000, which we know now that number is incorrect. Based on that, he agreed with Mr. Brown's as-applied challenge and granted his motion to dismiss the case based on the Second Amendment. Now, the United States government then decided to appeal that decision up to the Fifth Circuit, and in this case, Pam Bondi and the DOJ are continuing to argue against the Second Amendment, and they're arguing that these machine gun restrictions do not violate the Second Amendment. In the Trump DOJ's recent brief, they argued that the lower court's decision was an error. They stated that machine guns are not typically possessed by law-abiding citizens for lawful purposes. Instead, they are uniformly restricted, highly lethal, and well suited for criminal purposes. Given these realities, the court has confirmed that Section 922O's longstanding prohibition against machine gun possession is entirely consistent with our nation's historical tradition recognized in Heller of regulating dangerous and unusual weapons like machine guns. Consequently, they state the Second Amendment's protection do not extend to machine gun possession. They state that the district court's contrary holding should actually be reversed. Now, this is kind of the standard anti-gun arguments being made, but unfortunately, they're being made by the Trump DOJ. They also argue that the Bruin analysis does not override the Fifth Circuit's prior decision in Hollis, and that should still stand as binding on the lower courts and their decision. Now, the plaintiff here filed his response brief to that, and he continues to argue that the lower court got the analysis correct and that the Fifth Circuit should hear oral arguments in this case and affirm what the lower court said. He argues that the United States has not requested oral argument on the basis that the question on appeal is settled by binding circuit precedent and can be considered fully by relying on the records in the briefs. The appellee does not consider the question on appeal settled by binding circuit precedent and believes that oral argument in this case would assist the court. Therefore, the plaintiff here, the appellee, is requesting oral arguments. So the Trump DOJ wants to skirt oral arguments in the Fifth Circuit because they do not want it to go to oral arguments like they had to do in the 10th Circuit and present those type of anti-gun arguments to the Court of Appeals. They know if they have to go to oral arguments in the Fifth Circuit, they're going to have to once again walk out the anti-gun Second Amendment position that they also presented in the briefs, and they're going to have to argue against the Second Amendment in machine gun possession. And so here they're asking for the Fifth Circuit to simply rule on the briefs, rule on the record, affirm what the lower court said, and they do not want to go to oral arguments. Now, recently in this case, multiple 2A organizations have filed support briefs, amicus briefs to this case, pushing the Fifth Circuit to actually uphold the lower court's decision and send this to oral arguments. Now, in those briefs, the 2A organizations state that looking to history, the government is correct insofar as the only historical tradition the Supreme Court has identified that can justify an arms ban is on arms that are both dangerous and unusual. Thus, to meet its burden, the government here in this case must show that these arms in question are both dangerous and unusual. The district court correctly determined that the government has failed to meet that burden here. Primarily, the government failed to demonstrate that machine guns are unusual today and instead sought to rely on decades-old dicta to meet the test rooted in today. Put simply, regardless of one's views of arms at issue, the government did not carry its burden in the district court. Accordingly, this court, the Fifth Circuit, should affirm the district court's dismissal of this case. So this case is moving forward still, and the administration here, the Trump DOJ, is still arguing against machine gun possession, and they still argue that they are not protected arms under the Second Amendment. Even worse, they argue that the Fifth Circuit should not hear oral arguments in this case, but instead rule only on the papers and reverse what the lower court said. I think that this will ultimately make its way to oral arguments. I think the Fifth Circuit will grant review of this, and they're going to take this on oral arguments. And then depending on what they decide to do after the fact, this is probably going to get elevated. But the Trump DOJ really doesn't want to have to send this to oral arguments. They're trying to avoid that. My hope would be that they would change course in this case, but we did not see them do that in the Morgan 10th Circuit case. So I think if this goes to oral arguments, they're ultimately going to still argue the same way. So this is a critical decision, an important case, and a very important appeal that's currently in front of the Fifth Circuit. Hopefully this goes to oral arguments. That's kind of one of the main battles right now, is to get the Fifth Circuit to fully review this case instead of just simply deferring to what the Trump DOJ is saying, and simply just not defer to the Trump DOJ saying that machine guns are not protected arms under the Second Amendment. So as we get more information, as this unravels more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have a lot of things for you guys. We have the free legal guide that you can sign up for. Again, all you have to do is put in your email, and we email you over a PDF. And then you can check out the website, armscholar.com, where we have a lot of other things like channel merch and all of that stuff. So as always, thank you guys so much for all of your support. And never forget, this nation was built by Arm Scholars, and this nation will be maintained by Arm Scholars.